we want to go back to the big news that we brought you at the top of this hour. Donald Trump has been kicked off another presidential ballot, this time in the state of Maine, a decision that comes 10 days after the Supreme Court of Colorado ruled that Trump is disqualified from the ballot there due to his efforts to overturn the 2020 election that culminated in the insurrection at the Capitol on January 6th. Though that Colorado decision is on pause pending an appeal by the state Republican Party. There are 16 states that have been considering efforts to remove Trump from their ballots, including Michigan. The Supreme Court decided yesterday that Trump can stay on the ballot, and Colorado and Maine. Most of those are lawsuits working their way through the courts, but Maine's process was a little different. There, the arguments were made directly to the Democratic Secretary of State, Shenna Bellows. It was her decision to make. So we have her here. Shenna Bellows, the Maine Secretary of State who signed off on that decision, joins me now. Secretary Bellows, thank you so much for joining us on All In this evening. I'm just going to ask you up front, what went into making this decision? Was it your own research? Did you have a legal team together? Did you look at the Colorado decision? What was the process to come to the conclusion that Donald Trump should be disqualified from being on the Maine ballot?
Well, first, it's important, and thank you for having me. It's important to understand how Maine's process differs from other states. Under the United States Constitution, time, place, and manner, every state's laws around elections and the conduct of elections are slightly different. That's why, for example, in neighboring New Hampshire, you see more than a dozen candidates in both the Democratic and Republican presidential primaries, whereas in Maine, we have a very different process. We had 2 Democratic candidates qualify for the presidential primary and less than a dozen candidates qualify for the Republican primary. Now, under the law, I first make a determination about ballot qualification. We accepted Trump's consent form and petitions to be placed on the primary ballot. However, any registered Maine voter may challenge the qualifications of any candidate within a 5-day period. And then I am required by law, it's an authority delegated to me explicitly by the Maine legislature, to hold what's called a Section 336 challenge hearing. Both parties come, they present their evidence, they file briefs. I review only that evidence in the context of the laws, the facts presented, and the Constitution, and then I must make a determination. I'm duty bound to both hold a hearing and make a ruling. And under the law, there's a very compressed timeline. In evaluating this, I came to the conclusion that I could not, unfortunately or fortunately, wait for the United States Supreme Court to make a decision. The Maine law required me to issue that decision, which I did today.
Now, I have to say, not only is this an incredibly important decision, but it's a very brave decision. The Trump campaign has already come out attacking you. They have said that you are a virulent leftist and a hyper-partisan Biden-supporting Democrat. It goes without saying that we all saw what happened on January 6th. We've seen a tremendous amount of violence associated with any time someone tries to hold Trump accountable. We've seen death threats against the judges in Colorado. Was that a concern of yours? And has the state provided you with additional protection and support since you've come down with this decision?
First and foremost, it's important to know my oath to the Constitution, my obligations to the Constitution and rule of law come before any other consideration. No other factors could weigh on that decision and did not. I'm very fortunate. We are very fortunate here in Maine. We have terrific support from law enforcement, both within my department, from the Maine Capitol Police, the Maine State Police. I feel well protected, as I have been for my entire time as secretary.
So I have to ask this because I think this also speaks to your credibility. Maine has some of the highest turnout of any state in the union. I mean, Republicans, Democrats, independents. You have, Maine, even though as a state tends to vote for Democrats for president, you have one independent senator and one Republican. How do you do it? How do you get such high turnout in the state amongst all sort of political partisans?
I smile because we were #1 in voter turnout per capita in 2022. We are really proud of that. And we have a really strong framework of election laws that encourage citizen participation. We have same-day voter registration. We have no excuse absentee voting up to 30 days prior to Election Day. We make it really easy to register to vote, to cast your ballot, and know your ballot will be counted. And we're really proud of our national leadership in voter participation and citizen engagement in elections and in the democratic process. And that's why we take so seriously our obligations to the Constitution and the rule of law.
Secretary Bellows, there are people all over the country, independent groups, other secretaries of state, judges, legislators, lawyers who are watching you right now. Are you expecting to, or have you prior to this decision, has anyone reached out to you? Have other secretaries of state reached out to you and said, hey, how did you, I'm struggling with this. Could you help me as well? Or is this a decision that you're saying, hey, everything that I think is in this written decision, and I'm not really open to providing, counsel or assistance to any other states that may be struggling with this issue?
That's really important. The latter is the case. This decision is based on Maine law and the facts that were presented to me in the Section 336 challenge. It was really important to me to look at the evidence presented in the public hearing and the law and the facts presented in the context of Maine law, sections 336, 337, and 443. It's a very detailed decision. We lay out why under Maine law, the Secretary of State has the authority, indeed the obligation, I'm duty bound to make this determination. Laid out that the record demonstrates that, in fact, the events of January 6, 2021, which were unprecedented and tragic, were an insurrection in the meaning of Section 3 of the 14th Amendment. And finally, in reviewing the facts presented, the evidence, the law, the history, we determined under Section 3 of the 14th Amendment that Mr. Trump engaged in insurrection and therefore was disqualified.
So one of the things that you mentioned is that since anyone within a certain period of time can challenge a candidate's eligibility, you had people present the case that Trump should be off the ballot. And obviously you had people present the case that Trump should remain on the ballot, right? You had people from both sides making this argument. So here's my question. And I wonder if this sort of came up because it's always something I've questioned about sort of the Trump argument. Donald Trump claims that he was elected in 2020 and that the election was stolen from him. I mean, my understanding of the Constitution is if you've already been elected twice, you're not allowed to serve again. How did you deal with some of the arguments that you heard from the Trump side? And do they have an opportunity to appeal if they're unhappy with your decision?
Certainly. Mr. Trump was represented by counsel. This was an administrative hearing. I was serving not as an advocate, but an adjudicator, as an administrative hearing officer in the hearing. And Paul Gordon was one of the three challengers who brought a challenge, and he brought it under the 22nd Amendment, alleging that because Mr. Trump has said publicly that he won in 2020, that he was disqualified from appearing on the ballot under the 22nd Amendment. My decision also found that the facts were not in dispute. No party suggested that Mr. Trump had in fact won in 2020, and the 22nd Amendment did not apply in this case. There were other challenges brought by Marianne Royal and by a group of former senators, former Republican State Senator Kimberly Rosen, former Republican State Senator Thomas Saviello, former Democratic State Senator Ethan Strimling, and those challenges were brought under Section 3 of the 14th Amendment. And that is where my ruling did, in fact, find that Mr. Trump was not qualified for ballot access in Maine.
Maine Secretary of State Shenna Bellows, thank you so much for the serious work. I hope you stay safe, and I hope you stay committed to the work that you're doing for this country. Thank you.
Thank you.